morning everyone and good morning doctor. My name is Queenie.
My name is Tan Jia Huan.
My name is Samrita Sri Narainan.
Cindy.
My name is Siti Anis Izzati.
My name is Alia Maisara binti Mustafa.
In wearable contract, there are 5 elements affecting the caution. The first one is caution. Caution is defined in section 15 as the act of doing or threatening to do any act prohibited by the penal code, such as killing, injuring, or unlawfully detaining a person of property, with the intention of compelling someone to enter into an agreement. For instance, if someone wants Ahmed to buy his house for 300,000 and threatens to beat Ahmed if he refuses, Ahmed's decision to buy the house out of fear makes the contract wearable due to caution. In Kesama Anak Lelaki Lekcuman Das LWB Valiapa Cetia NLJ 119, a land ownership agreement was enforced under duress during the Japanese occupation of Malaya. The court ruled that the agreement could be void by the party concerned into signing it. The cause of caution, fear of violence. People may be forced into agreement because they fear being physically harmed if they don't comply. For example, someone may agree a contract because they are threatened with a beating. Another cause of caution is psychological pressure. Sometimes caution involves intimidation or mental tactics that scare a person into agreeing. This could include bullying or making someone feel guilty.
The second element is undue influence. The doctrine of undue influence is addressed in section 16, which states that a contract is considered to be included by undue influence if one party is in a position to dominate the will of another and uses the position to gain an unfair advantage. In similar terms, undue influence involves an imbalance of power between parties, leading one of the exert control or influence over the other, thereby compromising the fairness of the contract. According to the law, undue influence makes a contract viable, meaning that is the disadvantaged party has the option to set aside the agreement if they can demonstrate the undue influence affected their decision making. So let's see the example. Malaysia French Bank Berhad versus Abdullah bin Muhammad Yusof and Ors. This case highlighted the burden of proof in undue influence cases. Here are the defendant needed to prove that the plaintiff have a dominant position and had exploited this position to gain an unfair advantages. So let's see the causes as well. Authority over the influence party. Relationship involving inherent authority such as those between a parents and child, teachers and students, or employer and employees may lead to undue influence if the authority figure exploit their position.
So for the third one is fault the lion.
Fraud occurred when one party intentionally deceives another party to get them to sign a contract. This deception could include giving a false information, lying about certain facts, or hiding important details. The goal is to make the other people believe something untrue, leading them to sign a contract they might not have agreed to otherwise.
Well, for the example, Company A wants Company B to buy a large number of machines. Company A falsely claimed that the machine meet high safety standard, even though they actually don't. Company B, trusting this information, agreed to buy the machine. Later, when Company B discovered the truth, they realized they won't have made the purchase if they didn't know the machine did not meet safety standard. In this case, Company B can cancel the contract because they were misled by fraud. So for the last one is common cause of fraud in contract, which is economic pressure. Sometimes company might use fraud because they are financially struggling and see it as a quick way to secure contract.
Misrepresentation. What is misrepresentation? Misrepresentation is when someone gives false or misleading details to make another person believe something that is not valid. This can happen on purpose or by mistake. Misrepresentation can happen in many situations, such as in business deals, advertisement, or personal information. When a person trusts this false information, it can cause them to make poor decisions leading to harm or financial loss. Understanding misrepresentation is important because it can damage trust and result in serious problems for those involved. For example, a person sells a smartphone and claims it has never been repaired. Later, the buyer discovers it has been refurbished. This misrepresentation can affect the buyer's trust and financial decision. Causes: first, lies. One party intentionally misstate facts to deceive the other. Second, carelessness. A party makes false claims without verifying them. Third, partial information. Providing incomplete details can mislead.
Number 5. Mistake. The definition of mistake in section 21 provides that a mistake occurs when both parties are mistaken about a material fact concerning the contract. An example of a material fact is the existence of the subject matters of the contract. This means that both parties believe that the subject matter can be transferred when it has actually been destroyed or damaged and cannot be the subject of the contract. Example case: Raju and Harun enter into a sale contract for a Jaguar car. At the time the contract was made, the car had been destroyed in a fire. Neither party was aware that the car had been destroyed when the contract was created. The contract is void due to the mistake. Type of mistake. First, mistake of fact. Mistake of fact, a mistake made by both parties, refer to a situation where both parties in a contract are mistaken about the same fundamental fact. This shared misunderstanding can affect the contract validity. Law. Mistake as to law refer to a situation where one or both parties in a contract misunderstand the legal implication or requirement related to the contract. This can involve misinterpretation of statutes, regulation, or common law principles. If parties are under a mistake as to law that operates not in Malaysia, it has the same effect as mistake of fact. However, this is not the case if parties are under mistake as to law in Malaysia and the contract is not voidable due to such a mistake. Cases of mistake in contract. Mistake can occur when one or both parties have incorrect information about essential fact related to the contract, such as the identity or condition of the subject matter. A lack of sufficient or accurate information about a particular issue can lead to misunderstandings between the parties.
Then, a voidable contract is an agreement that remains valid and enforceable until one party chooses the void is due to specific legal reasons, such as mispresentation, undue influence, or lack of capacity. While the contract is deciding binding, the affected party has the right to affirm or rescind the contract. Understanding the implication of voidable contract is crucial for both parties, as it highlights the importance of informed consent and fair dealing in contractual relationships. Ultimately, recognizing when a contract is voidable can protect parties from unjust obligation and ensure that contracts are entered into voluntarily and with full understanding. Thank you.